Good evening to everyone in the English Constitution Society, the English Constitution Party. My name is Graham Moore. We are currently in the High Court, and there is the second highest court in the land, which is the Appeal Court, in front of 3 judges. I wanted to convey to you that we are not free men of the land. We're not these people in the background. We actually deal with the real law. And the closing speech, because the returning officer for Runcorn and Helsby and Sarah Pochin MP have basically challenged the election petition. They're worried about something. What is it they're worried about? I believe it is the fraud of the election. So I just want to run past you my closing submission speech. My lords and ladyships, we are gathered in this court under no ordinary cause. This is not the quarrel of man against man, nor the settlement of some petty dispute of property or contract. It is the trial of principle, the defence of liberty, and the vindication that most undoubted right which our forefathers bled to secure. The freedom of election. For what is an election, if not the very heartbeat of a free nation? It is the moment when the humble man stands equal with the mighty, when the widow and the workman, the farmer and the scholar alike place their trust by a single mark in one who shall represent them. In that act lies no less than the sovereignty of the people. A.V. Dicey, that great expositor of our Constitution, declared that Parliament is sovereign only because the people lend their sovereignty to it. It is a loan, not a gift. It is given for a term, a season, and at the end of that season, it must be returned. The truth was echoed by one of our own recent memory. Tony Benn, a man of Parliament, but above all, a servant of the people. Power, he said, is lent to me, and at the end of Parliament, I must return it. And Her late Majesty Queen Elizabeth II, in her gracious address to both houses, affirmed that the authority of her government derives solely from the people's will expressed in free elections. My lords and ladyship, what nobler chorus could there be? Dicey, Benn, and our late sovereign, all proclaiming the same truth, that the fountain of sovereignty is not found in the palace, nor in this court, nor in the Commons themselves, but in the people. And that fountain flows only when elections are free, fair, and beyond reproach. It is, therefore, a solemn charge placed upon the returning officer in the hour when he takes command of an election. He becomes no longer a mere functionary, but a crown officer. Upon his shoulders rests the sacred duty of ensuring the people's will is neither thwarted nor tampered with. He is answerable personally, criminally, and in tort for every act of wrong committed in the poll, the count, and the return. Yet what have we seen? We have seen the returning officer cease to be the guardian of the ballot and become instead an appointer of the member. We have seen the will of the people displaced by administrative fiat. And let the court understand, when the returning officer appoints, the people are dispossessed. When the return officer appoints, there is no freedom of election. And when there is no freedom of election, there is no sovereign parliament. In 2011, the people themselves were asked, shall we have another form of vote? Shall we depart from our custom ballot and adopt the alternative vote? And the people, in the clear light of referendum, said no. They chose their franchise, plain and uncorrupted. Yet what I and 3 other witnesses observed was not mere deviation, not some trifling irregularity. It was a crime against the foundation of our liberty, a trespass against our undoubted human right of freedom of election. My lords and ladyship, the freedom of election is no small matter. It is the root of the tree, the keystone of the arch, the sure foundation of every other right. Without it, our liberties are a house built on sand, our parliament a chamber of echoes, our constitution a parchment without life. And what then of rules and forms, of procedures and regulations? These, my lord and ladyships, are but the handmaids of justice, not her mistress. Shall the forms of law be raised up to crush its spirit? Shall technicality strangle the people's birthright? No prejudice is done to either party by hearing this cause, that the gravest prejudice, the gravest injustice would be done to the people of England were the court to close its ears to the subversion of their will. I say again, procedure is but the garment. Justice is the flesh and blood within it. Tabulated legalism must not be allowed to become the cloak of tyranny. And so, my lords and ladyships, I submit, this court has not merely the power, but the duty to act, to vindicate the ancient right of freedom of election, to guard the sovereignty of Parliament by upholding the sovereignty of the people. To refuse would be to betray Dicey Ben and her late Majesty, to betray the very principle on which our Parliament stands, to betray the people themselves. Let us then tear away the veil. Let us name this wrong for what it is. It is not a mistake. It is not an accident. It is not mere irregularity. It is usurpation, the theft of the people's voice, the silencing of their will, the pollution of their franchise. And if this court permits such usurpation to stand, then freedom itself is but a word, and Parliament but a hollow name. But if this court acts, if it strikes down this wrong, then it proclaims to England and to the world that here the ancient rights of free men are still guarded. Here the sovereignty of the people is still honoured. Here the Constitution still lives. My lords and ladyship, I rest my case. Let justice be done, though the very heavens fall. Thank you.